Incredible effort by Darren, I think, to get through 7 or 8 cases in about 15 minutes. So well done to you, and thoroughly fascinating. While we wait for my slides to now come up on the screen, I just want to ask the audience here, has anyone been involved in filing a trademark? Just to give an idea. By a show of hands, just to get the blood going. All right, so, and either personally or through an attorney filing a trademark. So we've got quite a large amount of people who's familiar with that road. And the reason why I ask, and really I'm ad-libbing here, I'm waiting for these slides to come up, so bear with me. And it's not calculated on my time, so that's the good thing. Is that if you look at Gerard's case, of course, it's all about the mark itself. If you look at salty cracks and snack cracks, there's a lot of debate about this particular trademark, the actual mark itself, and whether it qualifies for registration, or either inherently or by virtue of some other people around relative rights, or the second part is the state, the amount of the monopoly that you claim on the specification of goods and services that are on the register. So I used the analogy last year when you were talking about the sole cases, of those that you remember. You build a house and then you erect your electric fence around the boundary of that house. And the distance between your house and the electric fence is how much protection you've got. And what I'm going to be talking about now, which has been dubbed probably the most important trademark case of the century, is how big your garden can be. How far away must your electric fence be? And it's all got to do with your intention. So allow me to transport you to the United Kingdom. This is where this particular case has been dealt with. I'll explain why it's important that we look at the United Kingdom in due course. It involves Sky, who we all know, the big media and telecoms giant, and SkyKick, who we probably don't know, but it's a cloud, they have a software application for cloud storage and cloud migration. The facts very briefly are, I'm going to take you through a convoluted set of, not really convoluted, but just the flow over 5 years of these various court cases, talk about why it's important, and then maybe just some considerations for your own when you're filing your trademarks, and for lawyers as well who are enforcing others. So Sky sues SkyKick for trademark infringement. SkyKick denies and counterclaims for invalidity of Sky trademarks. I'll talk about it in a second. And the High Court finds the infringement of the trademark Sky and SkyKick a lot closer than snack cracks and salty cracks. I think you'd agree, although Gerard may disagree. And I think he did exceptionally well to win that case. But the court finds that they're far too close. Remember, the goods in this situation at this stage are identical. And this is the nub of the whole thing, is that Sky had applied for trademarks which include 23 classes of the 45 classes of goods and services. So in other words, their garden was enormous, right? And SkyKick had said, listen, you don't have a bona fide intention to use the trademark for that case, and therefore they should be held invalid. So this is the first court, the first time this particular situation had become before the UK Court of Justice. I had to refer to the CJEU, the Court of Justice of the European Union, and they referred 2 questions. Whether a trademark claiming computer software should be declared wholly or partially invalid on the basis that it is too broad and lacks sufficient clarity and precision. That's the first question. And the second question is, if you simply are bold and simply, it doesn't fit nicely in the sentence, but it's very important here for the question. If you simply have no intention to use the trademark, in this case, Sky for computer software, but they'd also covered a whole range of other goods, including, I think, deodorants. Is it bad faith? And can that trademark then be declared invalid, wholly or partially? So the CJEU, what happens then? It goes to Europe, and the way in which it works, normally you have an advocate general who makes an opinion, and the judges then follow that opinion in the CJEU. And in this situation, 95% of the cases, the judges follow that advocate general opinion. In this case, they didn't, giving the first hint of the debate, of the discourse that's happening around these 2 questions. The CJEU eventually decide that actually trademarks cannot be ruled wholly or partially invalid on the basis of a lack of clarity. In other words, you're allowed to have quite a big garden with as many flowers as you like. And bad faith requires an objective, relative, and consistent indicia to show that when the application for a trademark was filed, either it was dishonestly dishonestly undermine third parties, or you obtain exclusive rights for purposes other than falling within the functions, plural, very important here, of the trademark. It looks simple enough. There's quite a lot in that answer, but I'm going to skip that to find out how the local judge, then goes back to the High Court, back to London, and Sky's registration. What they did is the court sees they want to narrow down the registration. So they did find that there was a deliberate strategy by Sky of using their trademark applications as a legal weapon against others, right? And so they took the step of actually refining the specifications, and then they did the test for infringement. So they removed certain things, and then they tested for infringement. And they did find that actually SkyKick still, nonetheless, because of the fame of the Sky marks, still infringed, ordered the injunction and costs. Both sides unhappy with that decision, goes to the next level up, which is the Court of Appeal. And this is where they all wear wigs, I must tell you. So broad specification of goods are not on their own bad faith. This is what they find. They have a very conservative judgment. They go back and follow the CJEU ruling. And they start, just quickly read it, broad specifications of goods and services are not on their own bad faith, and a lack of intention is not in itself bad faith. And more is required. But they say that there must be need to show no commercial justification for applying to cover those goods, that the sole interest is to undermine other parties from applying those goods. You follow that? And that there was justification for the broad specifications of goods. And the justification was that there was an investment value in the Sky marks. In fact, that these marks were famous marks, and then they needed, as a matter of course, to protect that investment function, the advertising value of the trademarks, irrespective of if they wanted to actually use them for cloud computing software, to have broad specifications. Okay, so that's where the Court of Appeal decides. Many people, commentators in the UK, felt a little bit let down by that decision. They felt it was a bit of a cop-out, and it became quite controversial. So leave to appeal then is granted to the UK Supreme Court, and this is the equivalent of our Constitutional Court. And if you want to look at what the UK Supreme Court looks like, that's what it looks like. No wigs, more lords than you can throw a stick at. Those are the guys sitting in front. The chap standing up is a guy called Geoffrey Hobbs, a remarkable person. I worked there for 10 years, and he was really the registrar, the appointed person who gave a lot of really good judgments in the late 90s, early 2000s, and really actually an amazing person to listen to. I sat and listened to this thinking there's, by the way, 8 hours of debate on this, 7 of which go to the argument of bad faith, just to show the enormity of the debate on this particular issue. In South Africa, you're looking in the appeal maybe 2 or 3 hours if you're lucky on this. So just to give the weight on that. So listening to Geoffrey Hobbs was remarkable, barrister Sir Geoffrey Hobbs. And on the right-hand side is a guy called Speck. He's sitting down second to the right. He's the King's Counsel. And Debbie and I both worked for the firm that instructed them. Field Fisher is my old firm. So it was quite nice for me to see some former colleagues in the back row, just on the viewing. So for me, it was very interesting, but I would encourage any lawyer listening to this to go into this and really get an understanding of the debate around how big this garden should be that is going through from in Europe and in the UK at the moment. And we're currently awaiting the decision that was held in June 2023, and they did say that there was going to be a substantial delay, showing it once again the enormity of this particular aspect of law. So why is this so important, having sat through kind of 5 years in a very short space of time, in 6 minutes, I've got 7 minutes to go. First of all, it's fundamental to the trademark right. I think I've explained that. It's that second part of that trademark right. The second is that if you appreciate, and I'll just tell you for a second, that if you imagine the globe, United States, London, South Africa, Europe, and Australia, and that, in the US, if you've ever tried to register a trademark, you'll know that they'll only give you a registration for the marks upon which you actually use the goods, right? So that's one paradigm, one public policy decision. If you go across to Europe, they have completely the opposite. They will accept, you can, under the European Court, the community trademark, you can apply for all 45 classes if you really wanted to. So that's the difference between the two. And the UK sits somewhere in between. It requires a bona fide intention to use the trademark, and it can be bad faith if it's not, and that's the debate that we're seeing. I'm going to say that South Africa is actually between the United States and the UK on this. And the reason for that is quite important, because in the UK, although there's a requirement for a bona fide intention to use for those goods and services, there's no ground of cancellation for lack of bona fide intention to use. So you have to then make the jump that it then becomes bad faith. That's why there was that question, only to become bad faith, to get round to cancelling the trademark. In South Africa, under our Act, it's a totally separate ground of opposition or cancellation. So in other words, we don't need to jump across lack of bona fide intention to being bad faith to win it in these particular situations. The ripple effect of a UK decision, Gerard mentioned, we follow Europe. We've got a dearth of trademark of jurisprudence on trademarks. It's fairly substantial, but there is a dearth, certainly relative to Europe. We both follow the Harmonisation Directive. Our Act is 1993, their Act is 1994, and we have always traditionally followed the UK system. So their decisions have a ripple effect, not just to South Africa, Australia, New Zealand, and most of the English-speaking or the English-influenced countries within Africa. So it becomes a very important decision, and 7 hours of debate over bad faith will certainly have a ripple effect onto us. We have, as you know, or you may or may not know, but we've got a practice of accepting class headings. So if you apply for a class heading, clothing, footwear, headgear, pharmaceutical preparations, veterinary preparations, if it's in the class heading, in class 5, class 25, class 9, there's a massive one, includes things like optical stuff, cash registers, you will get the registration of your trademark. So there has been, throughout my career, 25 whatever years it is, and most of the people now, is that actually to put in class headings. It gives our clients wider protection as possible. It's always got to be caveated by this intention to use, I must just say, and we do that. But we do try and broaden out, and I think clients try and broaden out the area of protection as much as possible. And the role of the trademark attorney, of course, is to do that, to give as wide a possible protection as possible for the client within reason. And the importance of this is at the date of application. When does this intention have to be? It has to be at the date of application of the trademark. It's important because you have these practices that are in place. Right now, for example, trademark class headings are acceptable, and it's very difficult to say that they then later on are acting in bad faith when really you're following practice directions. Again, that's something that's happening in the United States. That's one of the arguments that was raised in the United Kingdom, but not so prevalent here. You still have to have a genuine, bona fide intention to use the trademark. And then finally, the last two, the impact of this decision is quite important because of the European system, and because a lot of those people use the European system to file Madrid or international applications as base applications. They use them to file as priority applications that then go, those specifications get drafted in the UK and often get mimicked in South Africa or in other countries of the world. So we have these big specifications of goods and services on the register. And it makes it very difficult to clear a trademark for use. Often there's no real commercial conflict, but you've got a blocking registration there. And it makes it very challenging for new entrants, especially small businesses, coming into the market to take marks, even though in practice there will be no likelihood of confusion. The flip side of it, if the UK decide to take this opportunity to really reduce it to a more US-style approach, what you're going to find that every time you're trying to enforce a trademark, you're going to get a counterclaim for lack of bona fide intention to use. So what it does is, although it makes it simpler on the one end, it makes it longer on the other end. And you've seen that case in the UK, which has a fairly efficient trademark system, has taken 5 years. Now imagine that situation in South Africa. It really could make the enforcement of these trademarks quite tricky. So we sit in a relatively precarious situation. I've got 2 minutes left. I'm conscious of time and I don't want to interrupt others. I've got 2 more slides that I'm going to do. I'm actually going to skip through them quite quickly. Simply in listening to those debates, I just isolated the various aspects that are of challenge. I'm not going to deal with those in great detail, but what I will do is just try and give you at the end just some take-home points to people in this particular audience of what you might do now, right? Because I think that's what's most relevant, although the aspects for me as a trademark attorney in the next 2 slides are very interesting indeed. So the considerations are, what is an intention to use? Is it a lack of intention to use, simply bad faith? Does it relate to all functions of a trademark? Does it mean to all goods in the specification? So if you've got a genuine intention on some goods but not on other goods, what does it mean for your entire specification? When you sign that form, you've got a genuine intention to use for all goods and services. Right? So the argument is if you don't, it invalidates the entire mob. Right? And then what about general terms like computer software, clothing, for example? Clothing, you've got wedding dresses compared to, lingerie or bikinis, completely different markets. Veterinary preparations is one, and I was just listening to Donnie's talk earlier. And then what is the intention to use? Is it an objective intention or is it a subjective intention? Where we are at the moment is it's a subjective intention determined objectively. And is the trademark system being abused? We saw in the Sol cases last year that actually there's a feeling by the local judges, it's certainly at High Court level, that it is in fact being abused. Right, so those are the other ones. Of course, there's an undercurrent of Brexit happening in the UK, which is interesting but not relevant to this particular talk. So where does this leave us now? And I think 3 things. I think if you're applying to register a trademark, I think you must spend a bit more attention on your specification of goods and services. Don't be lazy and use class headings, and make sure that you have a real and a definite intention to use the mark now or some foreseeable time in the future for those goods and services. So I think that's the one thing coming through. The second thing is if you have a broad registration now and you want to enforce it, I think you've got to give careful consideration that you may get counterclaims for lack of bona fide intention to use. And what do you do about it? Do you partially surrender your trademark in respect of certain goods? And will that help? Just a thought. But I think you've got to give some consideration when you try to take advantage, when you try and enforce your trademark, you might get some heat in return. And the third one is if you are now defending a trademark infringement action, this is a very powerful tool. Because if you look at specifications, you will find in the detail specifications of goods where there is unlikely to be a bona fide intention to use, and this is to your advantage. And that's it from me, so thank you very much.